So thank you very much. To conclude this conference, we want to have a short wrap-up session and open also debate for comments and observations that all of you who have been here for the last 2 days have had. I will open this by highlighting three overarching questions that I have been seeing as elements that run through most of the presentations here. And the first one is really the question if international law matters to everything that's going on between Russia and Ukraine at the moment. And Ashley pointed out in her presentation that Article 52 and 53 have never been really invoked. Christina showed that there's very limited judicial precedent. If there is some sort of invocation, it's usually in the back. Perhaps a separate opinion will take up these issues, but really there's no real case where it's at the forefront. Fisheries jurisdiction is 1.5 paragraphs on these issues, so it's been sort of in the background of issues. And also the example that Christina mentioned on the 1938 Munich Agreement, even if there's such a clear consensus that something was procured by force, getting that to be recognized is such a difficult task. So the first question is really, is international important to the matters at hand here? And I have three arguments why it is the case. The first one is to say that both Russia and Ukraine have stated time and time again that they want a legally binding treaty, and Russia wants to submit this to the Security Council to give it some sort of legal form. And I don't think it is irrelevant that parties to the treaty have such a clear idea of how to structure all these issues, and to that they want to use international law here. And I think one of the reasons is that most of the most important issues to resolve this conflict need some type of legal form to address it, particularly transfer of territory. You can't get that really without a legal change of title. And of course, also the question of amnesties and accountability. Those two need a legal setup. Then my second argument would be is that the validity of peace agreements and the entire legal setup is a precondition for other states to engage properly with the situation. So Helmut has shown how perhaps in the US, some more creative ways of setting up an LLT in Delaware can do things which you don't want, but most states want to use international law as a baseline for engaging with Ukraine and Russia after this territorial war. And how to do that will depend strongly on the way international law structures these relationships. And then the third argument is that one that resonated most strongly this morning. Let's say more the second order questions towards the question of if there is going to be a peace agreement. Those are inherently tied to international law. So exactly the question of accountability, but also reparations. All of these mechanisms that we're talking about need some sort of legal action. And I think that is really the role where international lawyers and also academia comes in, because for many of these issues, there is international legal arguments being made by all sides of the parties. Russia is making legal arguments through its tribunals, and here international lawyers can give meaning to what these concepts are invoked for, and that it is not devoid of any meaning, but there can be some sort of this construction and narrowing down. So I do think that there's both a role for international law, all these things, but also for the academic discussions and structuring we're doing here. Then the second question I saw as relevant is how stringent is international law on these issues. So when Dr. Kurinevich gave his opening address yesterday, he said, Ukraine will not sign on to any peace agreement that is not in line with the principles of the Charter of the United Nations. And I thought, well, that's a pretty strong statement, pretty stringent. There's not real room for compromise here. But throughout the last 2 days, I've been perhaps more nuanced to this. So I think if you take more Monica and Ingrid's approach, say prohibition of annexation is a distinct legal argument, there's really no way of going against this without deconstructing the entire international legal order. That leaves very little room. But particularly the points highlighted by Mark and Greg, that there's no set in stone lex pacificatoria, so that there's more legal leeway, and then also Sarah's and Asley's point to see that there's room for creative lawyering, shows that many things can be meant if you say we want to resolve this conflict based on international law, and that it doesn't really necessarily mean that it is an illegal resolution, even if it's only a creative resolution. And I think Helmut's contribution highlighted how there could be many ways of thinking about this, even if in the specific example of the special economic zones, they perhaps would not be the best. But still, international law is not that set in stone, in my opinion, and it's sort of really the job of lawyers and also academics to find out how the competing principles can also get into touch here. And then the last question I want to highlight is, what unit of analysis are we looking at? And I think there's two principal units of analysis when looking at the peace agreement. Do you look at it as a narrow agreement between Russia and Ukraine, or do you look at it as an aspect of the global legal order? And I think this tension has been resounding pretty strongly. So Sarah said that if you look at self-determination and Ukraine signs on to a treaty, that should be very strongly. And then who is the rest of the global legal order, which can't really be enforced, to come in? Perhaps Anne and I, who are concerned about the Security Council becoming ever omnipotent and doing whatever hegemons want to do, have a different view of this, to say, well, the global legal order is very much also decided in this concrete aspect. And I think Dr. Ruckert's comment this morning is very to the point on that. She asked, do the legal solutions we come up for Ukraine have to hold up for all cases, or is it okay if they only hold up for Ukraine? And I think this goes to the essence of the question, also on the questions of accountability and reparations, because if we say this can be a sui generis solution, then many of the questions on Article 52 and 53 don't really matter. But if we have the idea that international law should be coherent on this sort of then goes around. And I think striking that balance, and I think it must be a balance in some sense, will be probably the decisive question going forward. So I think those are sort of my three observations here, but I would invite everyone also to share their reflections, where these debates are going, what particularly interesting aspects you wanted to highlight from here, and how sort of thinking about the future of the Ukraine-Russia peace agreement from the perspective of international law also creatively can function. And I give to Professor Peters to moderate.
Yeah, thank you, Florian, for this brilliant summary or highlighting of some cross-cutting themes that came up during these 1.5 days.